preconditions, some free restrictions on him, that he will be coming to court at a certain time and date until the final determination of the matter against him. If at the final determination he is completely exonerated, fine, he will just go without all those pre-restrictions imposed on him. But if perchance he is found culpable, then in that situation, he comes back to the court, and the court will do to him as it wishes, whether to take him to prison, sentence him to prison, or to ask him to pay a certain amount of money as fine. Then he would go as a free man. But within the interim of between when he is accused for committing an offense and the time when he is either exonerated or convicted, he has only two options: either going to prison or staying within a community but under some restrictions. So it is those restrictions, the conditions for restrictions, that are called bail conditions. He has to stay with it, whether he likes it or not. If they say surrender your passport, you have to surrender your passport. If they said you cannot go out of the state, you cannot go out of the state. Once you do that, you commit something that will be liable to make the ball be revoked by the court. So that is any court that is going to consider his bail application, that there are no reasonable grounds. So in this situation, he will be granted bail. He will be granted bail until such a time when the police finish their investigation, and if they find that there is a need to continue with the case, they will continue with the case. If there is no need, they will send their file to the Ministry of Justice. The DPP will give an advice for the termination of the case. So that will be the end of the case. So these are the two instances. One, when an offense can be punished with imprisonment beyond 3 years, and it's not a capital offense. This is one instance. In another instance is when it is a capital offense. The allegation is of a capital offense, but there are no reasonable grounds. This is the instance. And the last instance is where there will be no bail. This is capital offense, where there are reasonable grounds. There are reasonable grounds, and it is a capital offense, so he will not be granted bail. These are the three instances. Or in another way, you can subsume it into two. You can say bailable and non-bailable. Bailable are the simple offenses. Those offenses are beyond 3 years imprisonment, and the capital offenses that have no reasonable ground. All of those are bailable. The only non-bailable is the capital offense. Yes. A person admitted to bail must be bonded. This is the provision under section 345 of the CPC. There used to be a situation whereby somebody is granted bail and he will be released directly from the prison and go without signing any paper in the court. This is totally wrong. It is totally wrong. An accused person must be bonded. He has to come to the court and sign a bond, a bail bond. I'm not talking about the surety. People who are thinking that it is only the surety that will sign the bond. No. The bond by the surety is even optional. But that bond of the accused person is compulsory. That is what is said in section 345. He should come to court and sign a bond. Because a bond, like I said, is an agreement to provide to the government certain amount of money if the accused person fails to meet the terms of the conditional release from custody. So since it is an agreement, and you just release an accused person without him bonding himself, then there is no obligation, there is no agreement whatsoever that he must come to the court on a stated day. The agreement is only between the court and the surety. So if he did not come to the court on the stated day, he has committed an offense, and that offense is known by law, and it has prescribed certain punishment. So somebody just to secure the release of somebody on bail, you wanted to translate it as punishment. Where are you going to take all those constitutional provisions, like section 35, subsections, and section 36, subsection 5, that has said an accused person is innocent until proved guilty? Where are you going to take it? Where are you going to take so many other sections, like the section that says you cannot punish unless there is an offense, and that offense is clearly codified? That is what I miss also. Clearly codified. Even if there is an offense, if it is not codified, it is not an offense. An offense has to be clearly codified by those who are responsible in codifying the law. Like in Zamfara State, it is the House of Assembly. They have to codify it. They said this is an offense. This is an offense. That is the catchword at the end of any definition section of an offense. They will say this is an offense, punishable so under so and so law. So it has to be stated this is an offense. So if you punish somebody without a clear offense, because bail process, it's not an offense. Yes. Ekan and JCA also said something. The essence of the grant of bail is to secure the liberty of an accused person who is presumed innocent until proved guilty, and also to secure his attendance at his trial. However, conditions are attached to bail in order to ensure that the accused person does not jump bail, interfere with investigation, or commit further crimes. Trial courts are enjoined to be liberal in their approach to granting bail and the conditions thereof in non-capital offenses. They are tasked to grant bail on favorable and affordable conditions. It is against the spirit of the law to impose excessive and stringent conditions for bail, as that will amount to refusal of bail. Where the conditions for bail are stringent, the trial court or an appellate court has a duty to vary the conditions. End of quote. From this background, we can understand that grant of a bail application and the conditions and terms to be attached to the grant are entirely the discretion of the judge or magistrate. It is only when they are stringent or excessive that an appeal court or the judge or magistrate may vary them. This is the position. Once an application is made before a court, the judge, and by judge here I mean both the judge of the High Court and judges of the Sharia court of whatever grade, the judge and magistrate will consider the application. It is his discretion. It is his discretion. It is part of the inherent powers of all courts. So we can whatever. It is a discretion. You cannot challenge a judge just because he exercises discretion. But if he granted the bail, but he put in stringent conditions, so it has become amphibious, is it not? Here he granted the bail. So you cannot say he did not grant the bail. He exercised a discretion. And he exercised another discretion of that is almost tantamount to refusing the bail. So that is why if you go to the High Court, you will be intelligent enough to agree that at least the judge granted the bail. So now you are not seeking the bail, but you are just seeking the variation of the condition he imposed. So that is the rule. So you can understand how law has been that tedious. He has gone. It is already an arrangement. So don't take a surety. Be very particular. Don't rely on your registrars in determining who a surety should be. If you have given a condition, be sure that the conditions are satisfied to your expectation before you release that accused person on bail. Is accused having a landed property, and the registrar will say yes, he is having a landed property. Show me proof. There is proof. So show me the proof. Let me see it. Let me see the proof, and in the proof, let it correlate between the ownership in that registration of title and the surety that you have brought before me. Yes. Because the whole essence of granting bail is securing the attendance of the accused. So if a fictitious surety has come and he has taken the accused person, and both the accused person and him are nowhere to be found, then the essence of bail process is already defeated. So, depending on the discretion of the judge or magistrate, it may even be required that he must be someone who is resident within the jurisdiction of the court or owns landed property within that jurisdiction. The judge or magistrate may even require that the surety must be a person of some standing in society, e.g. village or district head, provided that the aim is not to make the condition so stringent or unable to be fulfilled. There is no law prohibiting the requirement that a surety must be a man of high social status. Yes, there is no law preventing it. It is not an overbearing for the court to say that you have to be somebody who has a high social status in society, because those people clearly you will be rest assured they will not run away because of your case. If you bring a district head with the whole of his district as the surety, why will a district head run away just because he has taken somebody on bail and leave his district? Which kind of district head is he? Yes. So with all these accolades, however, about having a surety in a bail process, it is the discretion of the judge or magistrate in the criminal procedure of our course to put it as a condition. It is not compulsory. It is not mandatory. The Criminal Procedure Code and the Sharia Criminal Procedure Code are the main laws governing criminal procedure in Zamfara State. Section 5, subsection 1 and 2 of the law, establishing each of them clearly provides as follows. Crime or otherwise dealing with such offenses, end of quote. This is the position. So, for all offenses in the penal code, and for all offenses in the Sharia penal code, the flow and the ceiling of bail procedure. Yes, but even if it is considered that it is addressed to the court because of the words application for surety for bail application, which I earlier rendered as application by a surety in bail application, so many ambiguities will arise. There is nothing called application for surety in bail application or application by surety in bail application. The only application in bail process before a court is that of the applicant who is the accused person. That is the only application before the court. The accused person will make an application either by himself or through his counsel. Yes, he can make the application directly and sign. Or his counsel will write an application on his behalf. In the affidavit, you can see the affidavit will be made by the applicant or somebody who reported from him. Like a clerk in the litigation registry will say, I heard from the accused person, I barely believe him, so and so. So it is the applicant that will state the circumstances of his arrest and why he feels there is a need for him to be granted bail. Not the counsel, not anybody. So that is application before the court. If the court is inclined to granting the application, it will then put certain conditions. The application by the application is there. It was considered by the court. The court will put certain conditions. No surety is mentioned here. The court will put certain conditions. So it is part of the condition could be execution of a bond by a surety. So that is where the surety will come in. If the court is interested in surety, in the conditions it attached in the bail application, it will say there has to be a surety, or there has to be a reasonable surety with landed property, with so and so. So it is only when the court initiates this process that the question of surety will arise. Otherwise, no surety will come to the court and say, I'm making an application to be a surety. We will arrest him. What is his business coming to our court saying that he wanted to be a surety? Who called you? Yes. The court, if satisfied, will allow the applicant to bring the required surety. Consequently, the surety will execute the bond. This is the ways of the court. Its judicial powers extend to all inherent powers. Judicial decision is one of such inherent powers of all courts. I explained this earlier. Another ambiguity is that the provision of the section intends to control transaction of any business. That is what the section said. It says, assessment as precondition for transaction of any business, including, not limited to. So it started enumerating. So it's for transaction of business. That is the position of the law. As a revenue agency, it is understandable that the Zamfara State Revenue Board should be given all cooperation to block leakages in revenue generation, one of which is tax evasion or avoidance. I understand that evasion is the illegality committed, but avoidance is another intelligent way of somebody reducing, but the burden of tax on him. So it is a duty of the board to also find a way of bringing him back by law. Yes, but before bringing him back, tax avoidance is not an offense. But if they find a way of bringing him back to pay the tax and he didn't, that is where tax evasion or defaulting will come in. Yes. So, but I said court is not a business consortium, neither a market where transaction takes place. They are talking about transaction of business. Court is not a place of transaction. It can help in punishing tax evasion. It can help in punishing tax evasion or illegal reduction of taxable income. But it cannot serve as an agent of the revenue board. Yes, it cannot. Yes. Yes, the board should do the needful in ensuring that offenders are identified and brought to court rather than using seamless bail process as a bite to catch tax defaulters. They should go to the field and do their homework. They bring all those tax defaulters, they should bring them to the court and see what the court will do for them. Yes, but they cannot hide just there and under the umbrella of the court to see that somebody respects their tax clearance. Yes. Suretyship in relation to bail is not a transaction of any business. If perchance the bond is to be forfeited, it will be forfeited to the government and not to the court. Yes. So that is why the court the government may get revenue if there is forfeiture. But other than it, they have nothing in the bail process really. The only leg I struggle to consider is to see if the Zamfara State Consolidated Revenue Law 2020 abrogates the provisions in Chapter 29 of the CPC and its identical chapter also in the CPC. It did not do so. Without abrogation of the chapters or any declaration by court of their invalidity, they are extant and subsisting. You know how to abrogate a law. Mention it clearly and say, without, like if you can say without any prejudice or whatever, so law is hereby abrogated. So the only conditions attached in bail applications that are found in the CPC, there was no abrogation whatsoever created by this law, Consolidated Revenue Law. There is no abrogation mentioned. The CPC is a specific law. This law is a revenue law. A different law is a general law for revenue. It cannot jump up and change. And it is even later in time. If it so wish to abrogate, it will do so. It is later in time, not earlier. So if it wishes to abrogate, it can do that. It did not. So the better procedure is to amend the CPC or the SCPC if this tax clearance something is going to have any effect. But it will not jump up from the revenue law. Yes. Without abrogation of the chapters or any declaration by court of their invalidity, they are extant and subsisting. Yes, up to now, we have not received any declaration by any court, up to Supreme Court, that says the discretion of a judge to grant bail, yes, is curtailed. We have not had this decision, and there is no law that has made any allusion to that. But this will not preclude a judge or magistrate in his discretion and for the purpose of judicial public administration only to demand that a surety may show evidence of payment of tax or NEPA bill or driver's license. All these are means of confirming your residency, is it not? Yes. If you are paying your NEPA bill, we know you are, we know where you come from. Is it not? If you are paying your tax, we know where you are staying. Because anybody staying in Zamfara must pay tax. Even the civil servants that are working with federal agencies, they have to pay tax to Zamfara state, not to the federal government. They have to pay tax to Zamfara state. So by paying tax, we know where you are staying. So the court will do in its own discretion. I am emphasizing in its own discretion, not by creation of another law from somewhere. Yes. Or any means of identification so that confirm the residency of a surety, but certainly not to be an agent of the revenue board in detecting for them tax leakages. No, yes, it is in no way the business of the court to do so. Thank you for the patience.
My Lord, the Honorable Justice Bello Kucheri, for a well-written and presented paper. His Lordship has looked into the provisions of the law with regard to power of the court to release an accused person on bail. Like he has stated, the powers are clearly stated in the provisions of the Criminal Procedure Code and Sharia Procedure Code. Under the Criminal Procedure Code, we have Section 340, which specifically says where the offense does not exceed, the punishment for the offense does not exceed 3 years. That then there is automatic, unless the prosecution will show why such an accused person will not be released on bail. The second instance is where the offense or the punishment exceeds 3 years. Under that provision, that is Section 341, subsection 2, certain conditions must be satisfied by the accused before he is to be released on bail. There is the third instance, that is where an accused person is arraigned before a court for a capital offense. Under Section 341, subsection 1, it says persons accused of an offense punishable with death shall not be released on bail. But then, under subsection 3, where there are not reasonable grounds for believing that he has committed the offense, but there are sufficient grounds for further inquiry, the court can now exercise a discretionary power to release him on bail. Now, there is another instance where maybe somebody has been granted bail by lower court, and that court, impose certain conditions, stringent conditions, which that accused person cannot satisfy. Of course, he can run to High Court and apply for reduction of the bail conditions or for the court to vary the conditions. Now, under Section 345 of the Criminal Procedure Code, both the accused person and the surety must sign a bond. Because under that provision, the word shall is used. That an accused person shall sign a bond, surety too shall also sign a bond. So two conditions, both the accused person and the surety must sign a bail bond before the accused person is to be released on bail. His Lordship has clearly stated that the discretionary powers of the court, of course, are under the Criminal Procedure Code and the Sharia Procedure Code. And by the provision of Section 36, subsection 1, subparagraph 15, that power cannot be curtailed. If at all, that was why I said in the beginning, when I made a remark, I said, well, I'm happy they are here, so that they can listen very well. If there is anything they think, they can go back and amend Let them go and amend. And he has stated it clearly that unless the provision of the Criminal Procedure Code and Sharia Procedure Code are amended to include that particular provision, even with the ambiguity there, because they like he rightly pointed out, it says application for surety. There is nothing like application for surety. The application is by an accused person or his counsel, as he has stated. So if they feel they want any provision or a condition to be included, they should go back to the framework of that law, so that the Criminal Procedure Code and the Sharia Procedure Code will be amended and certain condition is to be included in that. Unless that is done, the discretionary power of the court to release an accused person on bail cannot be curtailed by any provision of that law. Thank you very much.
And for me, I do not think the intent of this section is to make court a revenue generating agency. If I may give example before I make my point very clear, my lord. When you file a document before a court of law today, we collect filing fees. When you do other business with the court, there are amount of money, no matter how negligent that amount is being collected by the court. And this money being collected by the court are by all intent and purpose revenue. And nobody ever said, given the court that responsibility to collect such amount is all tantamount to making court as a revenue generating agent. It was never the intent. So that one is even bigger in terms of application than this one we are talking about today. Because this section is not talking about asking the court to collect the money, or asking the court to ask somebody to go and pay before I can grant this person a bail. The section, I concede to the grammatical dislocations and poverty in the context. I will just take it as you corrected it. So,
are you representing the revenue?
It was mandated by the law to take some discretions. We don't have anything against this. What we are saying is, when you are exercising that discretion, you always leverage on something that will guarantee the presence of an accused person.
If he did not pay the tax, how can he bring the tax to the answer?
I will get to that place, Manoj. I will get there. Manoj, what we are saying is, when you are looking for to secure the presence of an accused person in the court of law, you will have to look at, to some extent, somebody that will stand in for him in the name of surety, like he rightly said. And you are putting a surety because you want somebody you can rely on. So by the time this guy jumps in, you have somebody to call upon to provide that person. And what we are saying by putting that section there, my lord, is this. Court normally asks for certificate of occupancy, never been, to say, okay, when you are standing in a surety to such a person as an accused person, bring your NEPA bill, bring your certificate of occupancy. The only plea we are making on behalf of revenue, I'm a taxman, my lord, that's why I'm speaking. Yes, I'm a taxman. My lord, what we are only asking is this, in exercising that discretion, because if you put 3 people here and say, I want to know who is more responsible between them. One is a person that has a certificate of occupancy, meaning he has a land property. One has a NEPA bill, meaning he is identifiable by the presence, by his address. And the third one is a person who willingly go and pay tax for development of the state. If you ask me, I would rather say the one that look more responsible among the state is the person who pays his tax. What we are saying, my lord, is this. Yes, my lord, what we are saying, my lord, is this. Please, when you are exercising that discretion, the judges, when you are exercising the discretion of giving out a bail, please consider TCC most appropriate in terms of securing the presence of an accused than any other means of identification, like say, oh, that is. That's the first comment, my lord. Thank you very much. Then the second one, very quickly.
That's a question.
Okay.
It's a question.
That's lower.
Okay, sir. And the second thing, my lord, is based on what Kadi Isa Hamza said. I believe I can find that revenue by this section, revenue is not asking for court to collect revenue, and it's not even saying I cannot give you bail as a surety. till you pay tax. It's only saying you must prove to me that you are a good person. Thank you very much, my lord. I think I will ask Thank you very much, my lord. So if there is
determine a case brought before him, and same judge lacks the power to entertain a bail application. Second question, my lord, is you said where a judge exercises his discretion to grant or to refuse bail, the aggrieved party cannot appeal, but he can apply to an appellate court, maybe in case of Sharia or Sharia court. Where that application is refused by a lower court, the aggrieved party can apply to appellate court. So my questions on this is, does the constitution of the appellate court remain same? That is to say, one judge, or there must be two, because we have a lot of problem on this. Then my lord used shall. This shall we are facing a lot of challenges, particularly in Sharia court, because whenever we apply for a bail under section 301 sub 2 paragraph A to C, the prosecution counsel or the prosecutor will say, no, a person accused for an offense punishable with imprisonment exceeding 3 years shall not be released on bail. Nevertheless, upper Sharia court, blah, blah. My lord, what I want to know here is that, does that shall not ordinarily release on bail empower the same judge to say he lacks power to refuse the bail by doing this? Then lastly, my lord, you said the judge has a right or has a duty to stipulate conditions for granting bail, especially where the offense, the punishment for the offense exceeding 3 years. So if such conditions are stipulated, does the counsel to the complainant or prosecution has right to ensure that such conditions are fulfilled before release of the accused person? Thank you very much. Jafar, I am learning my practice from with DM Lasco and Co. Ni'ima Partners.
Competent legislature in the case of the first state means the House of Assembly. So for that law to be applicable for our court, within our courts, it has to be codified by that assembly, given its meaning together with punishment. It do happen in the first states many a times that maybe the governor will walk off in the night, or after a meetings, a resolution will be reached and said an executive order has been signed, and that executive order and being signed by the governor will now lead to the security agencies to be arresting people and be taking them to court, especially Sharia courts. And you find out that they will be tried, sometimes they will be taken to prisons. I want more clarification whether this executive order can be applied by our courts and a punishment will be provided for offenders of that executive order. Thank you.
To in granting bail application in a case maybe involving a landed property worth 10 million naira. I will link this question with the recent case of Court of Appeal in Ndume versus Federal Republic of Nigeria, where the court says a court who granted bail, who granted the accused person to bail and he jumped bail, and that court has no power to remand the sureties. I have been in this dilemma, so I know my Lord will make it very clear. Thank you.
Did not apply for the bail, and then no counsel to apply on his behalf. Whether the court, a magistrate, can so much to grant an accused person to bail. And if possible, on what grounds? What are the grounds to be relied upon? Thank you.
But where a registrar is collecting the filing fees and whatever, he is a revenue collector, yes. But I said the court should not be an agent of the revenue board, meaning what the revenue board should do as the principal, then the court will do it on its behalf. No, the court will not do that. The revenue board should go out in the community, find out those tax defaulters. But when you want to hide under the umbrella of the court, to find out the tax defaulters through this bail process and say no, court cannot be an agent. Yes, magistrate entertaining bail application, an issue raised by Ali Jafar, and I think it's almost the same issue raised by His Worship Saad Gurmepori, where a magistrate can remand a person, but you cannot grant him bail. You should read the CPC as a whole. It's a, what do we say, it's an organic whole. Previously, a magistrate has the power to conduct preliminary investigation. So he takes all the cases. For those cases he has jurisdiction to entertain, he will just continue up to the final conclusion. For those cases that he cannot determine, so he will take the investigation only and frame a charge which will be sent to the High Court. So that segment is the one removed. The segment of taking further judicial act after the time when he is going to frame a charge is completely removed. But the section that says you bring anybody accused of an offense to the nearest court, not the High Court, just the nearest court, just bring him there, so that the court will mediate or will give direction to the police on what to do. Because the police cannot keep somebody in their custody for more than 48 hours. It is 24 hours in some circumstances, but maximum is 48 hours. So to circumvent this problem, all cases are taken to court. It is the court that will give direction. Anything, and bail application is a judicial act. You cannot take further judicial action after the removal of the section concerning preliminary investigation. You cannot take that judicial act. Your only thing is to take him to court, to the prison. If there is any direction you give to the police to continue their investigation. That is the only thing. And if the magistrate cannot grant bail, some other courts can do. So what is the big deal? Even in the High Court, it is not the trial court that will grant somebody bail. It's another court. Another court will grant the bail, and another court will continue the trial. So you do your own job and allow others that were given the power to do their own job also. That is the position now. A magistrate not entertaining, okay. Appellate court in bail. You are talking about Ali Jafar, about how many number of judges that are going to sit. That is why you missed the point. I didn't use appellate court. I said fresh application. Fresh application. If magistrate refuse an application for bail, you go to High Court with fresh application, not an appeal. So you can understand, if it is appeal, then you will, this academic issue will even come out whether it's two judges that are going to sit. But constitutionally, even any appeal can be heard and determined by a single judge. Yes, by a single judge. It's not compulsory that there has to be two judges. A single judge can determine it. In any case, it is not an appeal. It's either a fresh application or a judicial review. All of it is by a single judge.
Section 342.
Yes, and Section 342. Yes. And there's an issue raised where you find dilemma in some courts where they said the word shall is compulsory. The section 41 subsection 2 says shall not ordinarily be released. Ordinarily is the catchword. This shall is relating to the ordinarily. But the section continues, but he may be granted this. That is why in my paper I said, I bring 3 instances. One, where he is to be granted bail. He is to be granted bail is like saying he shall be granted bail. And the second one I said, he may be granted bail. So this ordinarily, this shall is relating to ordinarily. Yes. Yes. And the conditions to be fulfilled, like what the prosecutor from the counsel from the ministry has said. These conditions that are specifically stated in section 341, subsection 2, A, B, and C. Is it not? Whether it is the duty of the judge to see that all the conditions are fulfilled before he releases the person to bail. If it is the prosecution that will show to the court why he thinks these conditions cannot be fulfilled by the accused person, it is not for the court. It is for the prosecution to bring cogent reason why he thinks, and not only stating it that because the accused could not do this, the accused could not do that. Just saying it for the mere saying cannot do anything. No, the judge or magistrate will disregard your submission and grant the applicant to bail. In any case, you know the backdrop about all this is that bail is the discretion of a judge, not prosecutor. Yes. Yes, and there is an issue of where somebody is accused of maybe embezzlement of about 10 billion, but he is put on a condition of on a bail on a bond of, let's say, 500,000. Yes. So in the event that he did not come back to the court, what will be the position? Like one, there are 2 issues here. One, I said the bail bond should be sufficient. Should be sufficient. You consider the allegation against the person in granting, in putting up the bail bond. You should consider it. If the court did not do that, like you have always been saying, that discretion should be exercised judicially and judiciously. So the court should do that. Another leg is, this forfeiture is to the government. Do you know why? It's not money to be given to anybody. It's to the government. Because you remove the government money also to go in search of the accused person. This is the way the money goes. This is the money is going out. You cannot keep it and give it to the police to go and be searching. No. Throw it up into the government coffers. Subsequently, ask the whole of police of Nigeria to go in search of him. Whatever they do, they spend is at the government expense. So the government was paid already. Yes. Okay, for this section 38, it's understandable. I think nobody comes. So on the recovery, they come back and they say now they are looking for. Fortunately, inside the excuse me, sir. Yes. And the one I have done
كما باركت على إبراهيم وعلى آل إبراهيم إنك حميد مجيد. يا الله يا رحمن يا رحيم يا حي يا قيوم يا ذا الجلال والإكرام. يا إلهنا وإله كل شيء إله واحد لا إله إلا أنت اللهم أحسن عاقبتنا في الأمور كلها وأجرنا من خزي الدنيا وعذاب الآخرة ربنا آتنا في الدنيا حسنة وفي الآخرة حسنة وقنا عذاب النار سبحان ربك رب العزة عما يصفون وسلام على المرسلين والحمد لله رب العالمين.